We are going to talk about evolving legal issues in emergency medicine. This chapter is written by Greg Henry, and it reads more like a rant by Greg Henry, which if you've ever heard Greg talk, anything he ever says sounds like a rant. But at any rate, he is probably the reigning expert on emergency medicine, medical legal issues. And he's got some good points in here. We're not going to do a whole lot on the med-mal stuff because there is we beat that horse to death, and there's not a lot to say about it. There's a couple points to be made here. Someone brought up the article or the point about Peter Rosen testifying in Georgia, and Georgia had a really nice system, and apparently he's turned it on its head. This great author of this textbook came in and used all the appropriate expletives to describe this as gross and unbelievable negligence type of thing, which brings up a whole nother point, which is fairly prominent practitioners, not just in emergency medicine, but in any field, going outside their state to the other side of the country to testify for plaintiffs in really ridiculous cases. And it's a stream of income. And you can blame the attorneys all you want, but if there is a doc out there who's willing to back up their claims, then they're just taking advantage of it. The worst plaintiff's attorney in the country can't do anything unless he or she has a physician that says that you did something wrong. And I do a lot of defense type stuff, and I am absolutely amazed at some of these arguments. And as a physician, they make no sense at all to me, and I go, this is a ridiculous argument, but the attorneys I work with will say, that's true. There's no logical aspect to it. However, if they can get away with saying it in a court of law, there are people on the jury who are going to believe it, and they're not as schooled in the science of medicine, and that's why you get away with it. So I think that the real problem is not just the laws and the attorneys, it's the physicians willing to prostitute themselves to get a fee to say whatever needs to be said. So having noted that, that's exactly what happened in Georgia. A very prominent emergency physician made a bunch of claims that something was grossly improper, egregious, and against well-known and fundamental medical practices. And that then turned the whole thing over, which basically said that if you missed a fracture on an x-ray, it's kind of well within the scope of emergency medicine practice. There was a little bit of problem, but it wasn't gross negligence. This person has now moved that bar to say, oh yeah, I can make anything sound like it's gross negligence, and so therefore there's really no protection at all. It is something interesting Greg mentions here, that in 2015, Georgia's Senate Bill 86 was proposed, and it was actually probably the most interesting thing I've ever heard. And what the bill said was the following: Patient Compensation Act that calls for the establishment of a system under which a patient, via an advocate, whether that's an attorney or not, I'm not sure, would appeal to the system to investigate his or her injury. The record would then be reviewed by a rotating panel of medical experts in the appropriate field, i.e. you can't go out and hire somebody who's going to say what you want. It's just like the judge, it's picked from a panel, which makes sense because I've been asked as a defense guy to say something outrageous, and you say, no, I can't. They screwed up, I can't defend that. But they can always find somebody who will say what they want. There's no side gets to pick them. There's three people, that's it. They get picked at random. If the panel agreed that the injury was avoidable, the case would be referred to a compensation committee for payment. Kind of makes an awful lot of sense that this would be the best way to do it. His quote, it was logical, practical, timely, and of course defeated. So that's Greg Henry's quote. Let's move on to some other topics that are in here. Management of the disruptive physician. In 2016, do we still have docs who come down and throw things around and scream and yell in the emergency department? Yeah, they're probably the same ones that behave that way in the operating room or on the floors or in the ICU. And the reality of it is the state licensing boards have become much more aggressive at pulling back this behavior. And it's not the behavior they're after, it's the fact that behavior creates what? A hostile work environment. And there are laws on the books that say you cannot create a hostile work environment. So what they've done is they've recognized that they can't legislate this behavior. You can't say to the cardiac surgeon, you are not allowed to throw the hemostat across the room and curse. Okay, The guy could say, well, you know what? I just operate better when I'm disinhibited. Fine, you know. We'll give you a little ketamine before a really tough case. But the reality of it is he or she cannot create a hostile work environment. And if you're one of the scrub nurses or you're one of the anesthesiologists, and half the time you're paying attention to the case and half the time you're playing dodgeball with instruments flying around the place, you can't. That's a hostile work environment. And they've said that basically, if those individuals come up, we're the ones who are always stuck with, like, John, come here. Is there a problem? Come over here. Talk to me. Screaming at that nurse is not going to solve the problem, especially in front of the patient. Come over here. And if they don't come over, it's like, if you don't come over, I'm going to embarrass you in front of your patient. So let's go over here and talk. And you pull them aside and say, what's the problem? We had one that I loved it. One of the cardiologists came down. They were going to take somebody with a little bit shaky renal function to the cath lab, and they ordered Mucomist. And the nurse, thinking Mucomist, went and gave the antidote dose of Mucomist for acetaminophen, which is 10 times the dose that you would normally give somebody as to protect their kidneys before a cath. And it doesn't work anyway, but they still do it. A lot of these guys still do it. And he went ballistic. He's screaming and yelling, this is going to kill the patient, this is ridiculous. And at some point it was like, okay, come here. And he wouldn't come over, so in front of the patient we said, just so you know, this is the dose we give on a daily basis to somebody who's overdosed on Tylenol. And not only that, we give it a couple times a day to that individual. It's harmless. And the patient, of course, is embarrassed by his behavior. It's like, can you find me a cardiologist that's not in a diaper type of thing? But those kind of things happen. Well, what they said is the courts have consistently held that disruptive behavior is a legitimate reason to revoke or refuse renewal of hospital privileges. The courts have also used the standard that it is not what the physician did or did not do, but rather how his actions were perceived. The question we must now ask is, have we created a hostile work environment? So that's the key word. That's the key phrase you want to use, which is, listen, John, your behavior is creating a hostile work environment. This puts you at risk of losing your license and losing your privileges at the state level, not at the hospital level. You can bully the hospital administration all you want with, look, you know how many cases I bring in here? I make millions of dollars for the hospital. That works just fine. Once it gets beyond the CEO's office and into the state, they could care less about this, and you're going to lose your license. And once you're sanctioned at the state level, you're going to have a tough time getting privileges anywhere else. Once you tie it into their income, they kind of, oh, I understand, I'll be good. The other thing is that hospital administrators are now under the gun for this. The new guidelines say that if they permit this behavior, they are also culpable. So it's an interesting thing if your CEO says, will you stop riling up Dr. Smith? He or she brings in millions to the hospital. It's like, that's fine, but when they go, you're going too, because the state's going to include you in the sanctions. Let's see. There's the question, what are the issues regarding shared medical decision-making as they relate to the medical legal system? Well, the bottom line is the following. It's not whether someone signs an AMA form, whether someone signs a consent form. It's did you talk to them and were they involved in the decision-making? There's beneficence, which is I'm doing the best thing for my patients. And then there's autonomy, which is the patient that says, I understand, but I don't want you to do the best thing for me. I want to go home and take care of my dogs. Anybody not had a patient who wanted to sign out AMA because they had to take care of their dogs? Yeah, cats. Yeah, cats I could let die. I could care less about the cats. I usually encourage that. It's like, yeah, that would be wonderful. But the dog, I'm a dog person, so I usually drive them home, pick the dog up, and come back with them. At any rate, the buzzword now is shared decision making. So what you want, if you put that on the chart, I had a conversation with the patient, and we made a shared decision or shared decision making, however you want to make it. Put it down there. This is how we decided his care was going to go. He understood that he had unstable angina and he could die, but he wanted to go home. That's it. You don't have to write that huge paragraph. Our electronic medical record has this drop in that says, patient fully understood, they can go home, they can be injured, whatever, and didn't want to stay in the hospital. But I don't make people sign AMA. I don't get consents for anything. I put it. I have a note that drops in the chart that said I discussed the risks and the benefits of this procedure, and we're going to go ahead with it. And I usually, as I'm putting the chloroprepal in the patient, I describe, but this pacemaker is needed for, because your heart's going a little bit slow, and as you're putting the lidocaine in, you say, well, it usually works really well, but there's some complications. And then as you introduce your needle, you just talk real fast. And some of the complications include you might get an pneumothorax, you might hit the pulmonary artery, you might cut these or anything. And by the time they say what, you've already got the catheter in, so it's done. But the word you want on there, and this is the latest buzzword, is shared decision making. You want to include that on there. Last course we were at, there's a big legal medical guy in the audience, and who I've known for years. He used to be at my hospital. He did like a bazillion cases, both sides. And so I said to him, and he was a surgeon, I said, Salt, can you tell them what value a consent form is? He said most consent forms should be written on toilet paper. He said they're absolutely useless. Because no matter what you write, no matter how you do it, all the patient has to say is, I was so nervous I didn't understand a word that doctor said when I signed this. Now, how many people get consents for like LPs and CVPs and that kind of stuff? Some people do. I don't. And I don't think there's anything to protect. I do explain what I'm going to do. I don't just say, oh, could you sit up and kind of bend over? You're going to feel a little pinch here. No, but I don't get the sign thing. The other thing is it scares them. Remember back in the day, and looking around the room, some people maybe as old as me, you used to have to spinal tap every first time febrile seizure. And by the time the kid got there, the kid was absolutely fine. They were rummaging around the needle box and stuff. And you'd have to tell his parent, your child needs a spinal tap. And then you were supposed to get a consent for it. As soon as you ask for consent, this kind of red light goes on in the back of their head like, this is really dangerous, isn't it? It's like, no, actually, it's really not. It's easier for me to do the LP than to put the IV in the kid. And that's when I learned to give up getting consents. I said, yeah, we're going to draw some blood, we're going to get some urine, we're going to get some fluid from their spine, it's all good. I love doing this. I really like doing spinal taps on little kids, not because I like sick kids. Well, sick kids are fun to take care of, but not because I want to induce pain. But I like the 4-week-old that comes in with a fever. That's the only complaint I want out of a 4-week-old. I don't want they're breathing funny. They looked a little strange. I never know what to do with that. I know what to do with a fever. And I did one, and one of my colleagues said, she goes, I love doing LPs in like a 2-week-old. I said, me too. She goes, you know what I like? You don't have to find the inner space. The bone's so soft, you can go right through it and you still get into the spinal cord. And I thought, and I wonder how many times I missed the inner space and did just that. Yeah. Every now and then they come down, they go, we want to know why you're not doing it. And the legal beagles come down and I go, because there's no value to it. I said, we had a conversation. If you want, I'll give you the 400 articles that say it's no value to it, and they kind of leave. They first of all, if you're going to meet with them, you meet with them in the department on a Monday afternoon, okay? Because the place is freaking nuts, and they're so worried about all the other medical legal risks that are going on, like the undressed patient in the hallway, and somebody taking a history about somebody's sexual history in a room with just curtains next to the family of the other room that's listening like this type of thing. So they're all worried about that they finally give up on just the consent and leave. I always find that's the best time to meet with any administrator. I'm working Monday at 3. Why don't you come down about 2:30? I'll meet you in the department. And so first, there's a good chance they won't find it because they never come down there. And then they come, and their first comment is always, it's kind of busy down here today. And it's like, no, this looks like this every day. Maybe if you came down here once in a while, you'd know that. And they just get so antsy. That's it. They just can't handle it and they leave. I knew somebody who used to take, when the Joint Commission came around to do the hospital, what they would do is they would always have them up in the ICU, and they'd always have that really rammy, screaming patient they had sedated, and they would make sure that the sedation wore off at about the time they were in the room. So they were trying to ask them about their policy for this or the other, and this patient's going ballistic, 2 beds over, and finally they just go, everything looks like it's pretty good in here, I'm going to go look at the kitchen. So, all right, AMA. We kind of touched on this a little bit. This is getting very dicey. This is getting very risky. Greg talks about there was a case in 1914, the courts of New York, and what is referred to as the Cardoza case. You really know when somebody knows too much about this stuff when they're naming cases. And it said, those of adult years and sound mind may determine their own health. That's true. But you have to make sure that they kind of understand it. And I don't think anybody in this room has not lied to a patient in order to get him to do something you want. I mean, I've had people who it's like, listen, you had a really close call with this TIA. There's no question you are at risk for a big time stroke in the next 3 days. You need to get your carotids looked at. And they're going, well, you know, if I say, how long am I going to be here? You will be out by tomorrow morning. I guarantee it. You're going to be discharged by, in fact, if you're not discharged by tomorrow morning, you come down to this department and talk to me. I'm not working until tomorrow afternoon, but you come down here and talk to me. And we've all told those lies, because like, I just can't let this guy go home. So I'm going to say anything I can to put him in there. But this talks about AMA. And it brings up this case called the Kowalski case. How many are familiar with this? The Kowalski case, anybody heard about it? Yeah, a couple guys have heard about it. You must be from North Jersey, New York. No? Here's the story. Guy walks into the department and said, Mr. Kowalski walks in and says, he's drunk. And like most drunk patients decide, that's when they decide they want detox. So he comes in and he says, listen, I want to be detoxed. And the department says, fine, you know, crisis unit will see you, you know, once you sober up, here's your bed. They put him in a bed, send off some labs, and he's got an elevated blood alcohol level, but everything else looks pretty good on him. And the guy's reasonable, not combative, not, you know, confrontational. And he's sitting there, and after a while, he starts to sober up. And like everybody we know, who you let them sleep it off, the morning they wake up, and you go, you know, they'll be ready for you for detox in, you know, at noon. And he goes, I don't want it, and they leave. Right? We've both seen that. Well, this guy gets up and he says, I want to leave. And the staff says, well, you really can't. You're drunk. He says, no. I've decided I don't want detox. I came here for detox. I don't want the detox, so I want to leave now. And we've all had that where it's like, I don't want to stay. You can't make me stay. I've got my rights. You know, I want to talk to my lawyer. It's like, please, do you have your lawyer's number? It's 3 in the morning. Let's call him. You know, I just love waking these guys up at 3 in the morning. And usually, you know, we reason with them a little bit, and then they get some leather straps, and then they get some Haldol and some Ativan, and then they become very cooperative. And then in the morning, you know, somewhere about an hour or two later, they come out of the restraints. An hour or two later, they're trying to pick up the nurse or the tech, and then a little while after that, they go home, and that's fine. Well, anyway, he wants to go home, but he's still drunk. He's still got an elevated blood alcohol level. So the ER gets tied up with something else, and he leaves. He goes out, gets hit by a car, and becomes a quad. Okay. He then sues the hospital and says, you know, he was drunk, he shouldn't have been allowed to leave, and everything else. Fortunately, the doc and all the nurses' documentation was spot on. They all documented very carefully that this guy was awake, alert, conversive, not combative, fully understood what was going on, and everybody's documentation said exactly the same thing. So it got the one side won, then it went to another side, then it went all the way up to the Supreme Court of New York. And what they said was that the justices said, because he was an adult and reasonable ability to make decisions, carry on a conversation, and understand the nature of his acts, the hospital would have no right to physically or chemically restrain him, and that the patient was responsible for his own actions. It was further commented upon that the hospital had the hospital aggressively restrained Mr. Kowalski, they would have been guilty of assault and battery. Now, that's good news and bad news. The good news about that is if you can document that somebody fully understands what you are talking about, they can leave before they are fully sober. So certainly this guy shouldn't be making trades on Wall Street under this condition, but he clearly understood, I am still drunk, you know, I can make a stupid decision, I can walk in front of a car, that may happen, but I'm leaving. And we've all had people with alcohol levels, you know, above, you know, 0.38, 0.4, who are totally lucid talking to you. And what this says is, according to this ruling, you can't keep them. Now, if you've got the person who's obviously hostile and combative and whatnot, that's a different story. Just document really well that this person was absolutely a risk to other people, you know, in the condition they were in and needed chemical and physical restraint. On the other side, there was a case in New Jersey that went like this. Guy is drunk, gets in a fight in the bar, gets, you know, a head injury, punched in the jaw, hits his head, they bring him into the ED. The ED says, okay, you've got a head injury and you're intoxicated, and of course, you know, he's I want to get the F out of here, he's screaming and yelling, and he wants to leave and stuff, and they do what all of us would do. They restrain him, give him some Haldol, give him some Ativan, get a CAT scan on him. This guy, how many would let this guy go without a CAT scan? Nobody. I mean, there's no emergency physician ever that would do that. A drunk with a head injury, you don't say, fine, get the hell out of here. You know, the very first case I was asked to defend was a guy came in, hit in the head with a pipe, was drunk, combative, and the hospital threw him out, and he had an epidural. I was like, there's not a thing I can defend on this. The only thing that they got right was they got the sex right on the chart when they made it up. But everything else is absolutely wrong. Well, this guy then sues the hospital. The hospital, the courts, however it goes, says, yeah, he's right. He should not have been restrained. He should have been allowed to leave with his head injury and while he was intoxicated. And I thought, you know, that's just absolutely scary that you would say that, because this guy, you don't know he doesn't have an epidural or a subdural, until you get the CAT scan on him. And once you get the CAT scan, he sobers up. If he doesn't want his jaw fixed, I'm okay with that. You want to leave. You now understand your alcohol level's a little bit lower. You're calm. You're conversive. Those kind of things. That's fine. You can go. But you can't go while you are still grossly intoxicated. By my exam, I don't care what the number is, but by my exam, you're intoxicated and you have a head injury until I'm sure nothing's going on there. That I find extremely scary, and we'll have to see how that works out. Looking at the medical records. Yeah.
Does the law expect that emergency department personnel would put themselves at risk to restrain a violent and hostile?
So the question is, does the law expect you to jump in front of this 400-pound guy who's barreling down the hallway to get out of there? No, they do not. You are not to put yourself at risk. Now, what they may come back to you and say is the hospital should have in place a mechanism to restrain 400-pound psychotic patients trying to get out the door. But no, you are not put at risk. But you are expected, once they get outside, to have called the police and try and corral them and get them back in. There's a couple of things. It says hospital staff the hospital needs to educate staff not to snoop in records, but the hospital is not responsible if they do. That makes no sense at all. Although we have our hospital, and I fight with them ad nauseum about this. The nurses admit they do this incredible resuscitation, admit somebody up to the ICU, and then they want to find out how they're doing. So they want to, it's an electronic record. They want to go into the record and see what was the OR report, or what's the last set of vital signs, or what did the repeat CAT scan show. The normal stuff that you really want to know about somebody who you spend a whole lot of time taking care of. Hospital said no, they're not allowed to do that. And in fact, if because the medical record tracks all that, if that nurse is found in the record looking at stuff, that's considered a HIPAA violation. And I've gone to them and argued. I said, this type of feedback is absolutely essential to the proper care. Suppose the nurses and the doc and everybody did this, what they thought was this wonderful resuscitation for somebody with a bad pneumonia. Only it turned out they had congestive heart failure. Well, unless you learned that you went down the wrong pathway there, you're going to keep doing that over and over and over again. So it's important to get that kind of feedback, and we all like that feedback. How many people, when you as you're kissing somebody goodbye, they're going up to the cath lab with their STEMI, the last thing I always say to the cardiologist is, let me know what you find, right? You all want to know, the guy, so you want that call back that says, you know what, it turned out not to be coronary artery disease, it was Takotsubo. That one always floors me. It's like, damn, they had positive enzymes and everything else. Or the one that calls back and says, it was incredible. They had this really tight, like 99% LAD lesion. We were able to balloon it. We put 2 stents in. And it's like, okay, I know I'm doing the right thing. That we love that kind of feedback. I mean, that's what we thrive on. These laws, I think, are ridiculous. Interestingly enough, the HIPAA laws do not prohibit you from giving feedback. And it's not a HIPAA violation if we transfer a really sick kid to the PICU at the Children's Hospital to call up the next day and say, how's Twinkie doing? You're allowed to do that. And the hospital should give you that feedback. They're doing much better. We got them extubated. No, they're still on event. We're working to get them extubated. That's important information. All right, let's see. We talked about Waxman in that article about the med-mal stuff. There's an article about what are the best states to practice in. Some information about the national database. I just want to do a couple of quickies here. Towards the end, we got about 3 minutes left here. There's one where Mellick versus William Beaumont Hospital. And what they said was you need to know what your policies are in your hospital because you can hang by them. So if your policy says you're supposed to repeat the blood pressure every 5 minutes on somebody whose blood pressure is under 90, make sure you're doing that, or change the policy. And the policy should read, the blood pressure should be repeated appropriately as regard to the patient's existing blood pressure. I love it when people write very specific numbers in policies, because it almost always hangs somebody. So you will hang by that. So you should make sure that all that stuff comes out. It should say to the ability of the staff, or depending on the clinical circumstances. We get dialysis patients whose blood pressure is 90 on a good day. So you would have to keep repeating that blood pressure over and over on them. There's an article that said reaffirmed protection of peer review. Apparently that varies state by state. Some states there is no protection for peer review. Other states there is protection for it. This was kind of neat. What the plaintiff's attorney said was, I want to go look at the root cause analysis, where they did the peer review on this case. And they said, you're not privileged to that. And he said, oh, I don't want to see what they said. I just want to make sure the facts as presented there coincide with the facts as I got on my depositions. Unfortunately, the judge said, nice try, but no, you don't get that. This is an interesting one. This is in West Virginia. It's Tug Valley Medical Center. I don't know, if you have a name like Tug Valley, you probably aren't the Mayo Clinic of West Virginia. At any rate, this was a pill mill that was giving out lots and lots of meds, and unfortunately one of the ER docs got dragged into it because he saw some of these patients on occasion and whose dogs ate the prescription or whatnot, and he gave them 20 Percocet, and he got dragged into this as well. At any rate, what they said was all these addicts then sued the doctors and said the doctors made them addicts and kept them addicted, so all the crimes they committed weren't their fault, it was the doctor's fault. So all the robberies, batteries, assaults, and all those kind of things that they committed were actually medically produced. So it's like kind of, I was taking this medicine and it caused me to be confused and I made some bad, okay, that's a medically related confusion. Well, they said when they stole the purse from some little old lady walking down the street, it was the medicines that did it, that these doctors gave them, that made them addicted. And it stuck. The docs all went to jail. So it was interesting. The last final thing is, how many have nurse practitioners who now have their doctorate degrees? Right. And this is a case that's going down where a nurse practitioner introduced his or herself, when I was a male or female, as Dr. So-and-so, which is appropriate. They have a doctorate. If an astrophysicist walked in to take care of somebody with pelvic pain, he could call themselves a physician, a doctor as well. I can't call himself a physician. They can say, I'm Dr. So-and-so. I understand there's a neutron star in your pelvis I need to check out. But what the problem is now is the nurse practitioners, if they refer to themselves as doctors, they have to still identify themselves as nurse practitioners. So the recommendation now is that the physicians identify themselves as physicians. I am Dr. So-and-so, I'm the emergency physician. Or I know a lot of people say, I'm John Smith, the emergency physician. And the nurse practitioners can say, they can say, I'm Dr. Smith, I'm the nurse practitioner in the department. So they have to make that distinction when they use the term doctor.